So I know a lot of you are waiting with bated breath. This is after the Honorable Dolly M. Gee, or G, United States District Judge, held some kind of proceedings in chambers on defendant's motion to dismiss. Defendant, of course, is Cloud Imperium Games, otherwise known as the makers of Star Citizen. And the plaintiff, reminder, is Crytek, a German corporation. And here is what Judge G, can someone find out how I pronounce that? Judge G, how is this here? Here's what she has to say. On August 16th, Plaintiff Crytek filed the second amended complaint against defendants Cloud Imperium Games and Robert Space Industries, alleging breach of contract and copyright infringement. On September 6th, defendants filed their motion to dismiss, now before the court, seeking dismissal of Crytek's claim for breach of contract based on Section 2.4 of the GLA. I think it was the Game License Agreement is what that stood for. Having considered the parties' written submissions, the court grants the motion to dismiss. Plaintiff, a German corporation, is a video game developer, publisher, and technology provider. Central to this lawsuit is Plaintiff's CryEngine, a video game development platform and computer program. In 2012, defendants sought to develop a new game called Star Citizen, which would use Plaintiff's CryEngine development platform as its foundation. Because defendants sought to use CryEngine as Star Citizen's foundation, the parties agreed to a game licensing agreement, GLA, to support Star Citizen's development. This arrangement is at the heart of the dispute. Plaintiff alleges that around September 2016, defendants announced that they were using what they described as Star Engine, a video game engine in Star Citizen, in place of CryEngine. In December of that year, defendants announced in a press release that they had licensed and intended to use Amazon's Lumberyard game engine in Star Citizen in place of CryEngine. Plaintiff's initial complaint and its first amended complaint alleged various theories of breach of contract and copyright infringement against the defendants in connection with the GLA. Crytek's principal allegation was that the GLA prohibited defendants from using any other game engine besides CryEngine in Star Citizen or a spin-off game, Squadron 42. Defendants filed motion to dismiss. Court granted in part, denied in part. Although the court granted defendants' motion with respect to plaintiff's allegation that Section 212 of the GLA required defendants to build their game only using CryEngine and prohibited them from using any other engine, the court stated in a footnote that Section 2.4 may support plaintiff's theory of breach in connection with defendants' alleged use of another software engine in Star Citizen. The court did not consider the merits of such a claim. On August 16th, plaintiff filed the second amended complaint, now alleging a breach of Section 2.4 of the GLA. Plaintiff alleges that under 2.4, defendants agreed not to adopt or promote another game engine in connection with Star Citizen or to engage in various activities that might benefit game engines which compete with CryEngine. They go over the Federal Rule of Civil Procedure 12b6, motion to dismiss for failure to state a claim standard. The court may grant dismissal only where the plaintiff fails to present a cognizable legal theory or fails to allege sufficient facts to support a cognizable legal theory. To survive such a motion, a complaint must articulate facts enough to state a claim to relief that is plausible, at least on its face. And then there are various additional details the court goes into that we're going to skip here. The interpretation of a contract is a question of law unless the interpretation turns upon the credibility of extrinsic evidence. Extrinsic evidence would be evidence that's outside of the document, outside of the contract. Courts apply general principles of contract interpretation when interpreting the terms and scope of a licensing agreement. California law guides the analysis of a breach of contract claim. In California, the words of a contract are to be understood in their ordinary and popular sense that a layperson would attach to them. Courts must give reasonable and common sense interpretation of a contract consistent with the parties' apparent intent. The contract's meaning must be derived from the whole contract, and individual provisions must be interpreted together in order to give effect to all provisions and avoid rendering some meaningless. When the contract's language is disputed, the court must decide whether the language is reasonably susceptible to the interpretation urged by the party. On to GLA Section 2.4, the arguments before the court focus primarily on whether plaintiff has alleged defendants violated 2.4 by promoting other game engines. But Section 2.4's language implicates more than just promotional activity. It states, during the term of the license or any renewals thereof and for a period of 2 years thereafter, licensee, its principals and affiliates shall not directly or indirectly engage in the business of designing, developing, creating, supporting, maintaining, promoting, selling, or licensing directly or indirectly any game engine or middleware which competes with CryEngine. Plaintiff alleges that defendants breached 2.4 in connection with two different game engines, Star Engine and Lumberyard. Because defendants' interaction with each engine implicates different language within 2.4, the court discusses each separately. In Star Engine, plaintiff does not allege that defendants have sold or licensed Star Engine to any third party. It is also unclear from plaintiff's allegations whether supporting or maintaining applies in this context. The relevant provisions of 2.4 are the designing, developing, creating, or promoting of any game engine. The plaintiffs allege that defendants improperly promoted a competing game engine by at least September 24, 2016, when they said they were using what it described as Star Engine as a video game engine in Star Citizen in place of CryEngine. Defendants argue, first, that whether or not they ever promoted Star Engine, plaintiff can only state a claim under 2.4 if defendants have engaged in the business of doing so. The court agrees with defendants. The plain language of 2.4 does not prohibit a single act of promotion or even multiple acts. It prohibits licensees from directly or indirectly engaging in the business of taking competitive action against CryEngine. Moreover, while plaintiff argues that at least two courts have interpreted engaged in the business broadly, those cases actually work in defendant's favor. Plaintiff is correct that its first case, Advanced Transformer, interprets engaged in the business to have a wide variety of meanings, but the court limits those meanings to almost any activity engaged in for profit with frequency and continuity. Similarly, plaintiff's second case, in revisio, states that for a defendant to be engaged in the business of delivering video content, the defendant's product must not only be substantially involved in the conveyance of video content to consumers, but also significantly tailored to serve that purpose. Translated into language relevant to this motion, in order for defendants to be engaged in the business of promoting a competing game engine, defendants must not only be substantially involved in the promotion of a competing game engine, but must take actions significantly tailored to serve that purpose. Plaintiff has not alleged any frequent or continuous promotional activity with respect to Star Engine. Defendant's motion is therefore granted as to plaintiff's allegations of improper promotion with respect to Star Engine. Designing, developing, creating. Plaintiff argues that they breached that part of Section 2.4 by creating the so-called Star Engine. The court determines these allegations are conclusory. They merely parrot the language of 2.4 and state, without more factual detail, that defendants have breached the GLA. Such conclusions are not entitled to the assumption of truth at the pleading stage. And the court grants their motion there. As to Lumberyard, plaintiff alleges that the breach of 2.4 was by announcing it had licensed and intended to use Amazon Lumberyard. Plaintiff aims the same conclusory allegations described above at defendant's purported development, design, or creation of Lumberyard, but those allegations are inadequate for the same reasons. Plaintiff also argues in its opposition document that defendants impermissibly developed Lumberyard, but the court will not entertain factual assertions in an opposition to a motion to dismiss that are absent from the Second Amended Complaint. In other words, no new facts in a response. Plaintiff does not allege defendants sold Lumberyard to any third party, therefore the promoting or licensing language is what the court will evaluate. Similar to plaintiff's promotion argument regarding Star Engine, plaintiff argues the defendant promoted Lumberyard only once in connection with its announcement. Just like a single instance of purported promotion pertaining to Star Engine, this solitary act is insufficient to establish that defendants engaged in the business of promoting Lumberyard. The court therefore grants the motion to dismiss. As to licensing, the parties' arguments pertaining to Lumberyard focus on whether defendant promoted Lumberyard in violation of 2.4, but also whether they engage in the business of licensing any game engine that competes with CryEngine. Defendants assume that the licensing section of 2.4 only prohibits it from licensing a competing game engine to a third party, while certain passages from plaintiff's opposition imply that they believe prohibits defendants from licensing from a third party. Plaintiff does not squarely address this issue. To the extent that plaintiff alleges that defendants violated Section 2.4 by licensing Lumberyard from Amazon, the court agrees with defendant's interpretation of the agreement. In California, the whole of a contract is to be taken together so as to give effect to every part, if reasonably practicable, to each clause helping to interpret the other. When taken in context with the rest of Section 2.4, the word licensing most appropriately only prevents defendants from licensing competing game engines to a third party. Finally, plaintiff alleges that defendants breached Section 2.4 because plaintiff will now not receive the benefit it otherwise would have derived from defendants' use of CryEngine in Star Citizen and the attendant promotion of CryEngine. Plaintiff also argues in its opposition that defendants breached 2.4 through its prominent display of Lumberyard's trademarks in Star Citizen. Neither of these theories is sufficient to state a claim. First, nothing in 2.4 obligates defendants to promote CryEngine. While it prohibits defendants from engaging in the business of promoting competing game engines, it does not force defendants to take any promotional action on plaintiff's behalf. Thus, plaintiff's failure to receive promotional benefits owed to them does not implicate Section 2.4. Second, while plaintiff argues in its opposition that defendants coupled their Lumberyard announcement with the prominent display of the Lumberyard trademark, the Second Amended Complaint contains no allegations that this actually occurred. To the extent that the trademark display was a part of defendants' December 23rd announcement, it would still only establish a single promotional event insufficient to show defendants engaged in the business of promoting Lumberyard. Defendant's motion is therefore granted. Should a court dismiss certain claims, it must also decide whether to grant leave to amend. Courts should freely give leave when justice so requires. Courts should grant leave to amend unless the pleading could not possibly be cured. The decision to grant leave to amend a dismissed complaint lies within the discretion of the court, because it is possible that a plaintiff could cure the deficiencies identified in this order by alleging other or different facts. The court concludes that a final opportunity to amend is warranted. Therefore, the court grants leave to amend. Within 21 days of this order, plaintiffs shall file a third amended complaint. Thereafter, defendants shall file their response within 21 days. It is so ordered. So basically, if Crytek doesn't submit a third amended complaint at all, the case is done. I guess, or at least those claims are done. I'm assuming that there's no more claims to be adjudicated. And if they do submit something, it has to overcome this motion to dismiss standard, or else we're going to be right back here with another motion to dismiss and another dismissal. So that should be the conclusion of the Crytek case, which was just a really weird power or cash grab on Crytek's behalf. It was pretty darn clear what the licensing agreement was about. And they seem to have just suffered some kind of ego hit from the switch to Star Engine and Lumberyard. I don't understand that. Crytek isn't necessarily a bad video game developer. Why not just focus on that? It's weird.
And what strikes me is that this case is probably really expensive. It's been going on for a long time. And so whoever ultimately prevails, they would be able to ask for lawyers' fees from the other side, correct? Like, at least ask for them.
Yeah, they should. There's going to be a fight over what the proper fees are, but yeah, there's going to be a fees and costs motion going on here now. So thank you for joining me. I am Leonard French, your favorite copyright attorney. Really appreciate you tuning in, being interested in the law and the various ways it plays out. Thank you very much for our Patreon supporters in the month of December. Thank you to Justin Rogers, who has pledged $500 in December, as well as November. We really appreciate that, and we are working on his story. We'll be in touch with that very shortly here. Thank you very much to the $50 plus supporters: Jonathon Doe, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Andy, Verement, Tayne, William Gonzalez, Michael Pearce, Terry Crisp, Richard Fournier, Breakfast Demon, Spirit Bear, Jan Negrey, JAXMerrick, and Daniel Perez. And thank you to the over 200 $5 plus supporters who are scrolling on the LED panel behind me. And thank you to the total of over 400 Patreon supporters that are supporting our channel, making this whole thing possible. We're going to drop the Fallout 76 Fallout with Fallout website tomorrow as a video so that you can share that with your friends, and people who want to start disputes with Bethesda can use that process to start disputes. We also have some videos from last week that didn't get produced because I was busy working on this website. And thank you very much to Brandon for editing videos last week that I still didn't get to the final edit and didn't get out. It's my fault. Love you all. I am Leonard French, your favorite copyright attorney, and I will see you this week. Bye.